So welcome everyone to this specially scheduled CEO call. Pleased to have with us once again Jeff Tenenbaum with the Tenenbaum Law Group. He's spoken to us a number of times, and since he last spoke to us, things continue to shift and change in the landscape. So he's going to spend the first part of this call sharing some of the latest legal updates related to everything from reopening offices to restarting programming, what he's seeing from some of his clients around the country. And then we'll have time after that for your answer as many of your questions as we can. So, and you can feel free to put things in the chat, questions in the chat during Jeff's remarks. Time always goes quickly on these calls. So without further ado, Jeff, welcome to our CEO call, and I'll turn it over to you.
Thank you. Thanks, Dave. Good morning or afternoon to everyone, depending on where you're located. Nice to be with you again. As Dave said, I am a managing partner of Tenenbaum Law Group. We're a three-lawyer boutique law firm based in Washington, D.C. that focuses exclusively on the representation of nonprofit organizations across the country, primarily as outside general counsel. We work with about 400 different organizations right now, all different types of nonprofits on a very, very broad array of all of their legal issues, including, not surprisingly, spending a good part of every day counseling nonprofits on various legal issues deriving from the pandemic, from meetings and conferences to contracts, to workplace reopenings and kind of everything in between. And as Dave said at the start, this has very much been a moving target and an evolving process. In fact, I was just on the phone earlier today with a client who we helped work through cancellations of two large conferences last year, was able to get them out, as we were hundreds of other organizations, successfully without penalties under the force majeure clause, based on the various state and local restrictions on large gatherings that were in place at the time. We've kind of come full circle. We were then working with them on issues relating to how to safely hold in-person meetings and how to mitigate the organization's liability risk. And now we're back to counseling them again on ways to try to get out of their conference contract for this November in Texas, which is a challenge and not nearly as easy as it was last year. It is sad, of course, that we are back to dealing with potential conference and contract cancellations. And I think we all thought that we were going to be beyond that, but we're not, at least for the foreseeable future. And so all of this has legal consequences. There's significant potential cancellation penalties involved and all the rest. So, as I and my two colleagues have significant experience with all of these issues, and I've also done quite a number of these sorts of talks and webinars and whatnot over the last year and a half, we certainly have a lot of insights as to what's going on. And I want to try to answer as many of your questions as you can. I think that the primary areas that we're providing counsel are one, in the meetings area, both with respect to contracts, contract cancellations, new contracts, and kind of clauses and provisions that you want to be sure to include in those contracts to try to protect you in connection with a lot of these issues going forward, as well as holding in-person meetings and how to do it in a way that mitigates liability risk for your organization. So that's kind of one bucket of issues that we deal with quite a bit, including things like liability waivers and what sort of things do you want to get the hotel or meeting venue to agree to do. Should you require mandatory vaccinations for your attendees or proof of a negative COVID test? Are there any legal issues that factor into that? All of that whole big bucket of issues. And then the other big area has been workplace reopenings. And again, how can you do it in a way that protects the health and safety of your employees, mitigates your organization's legal risk? Should you mandate COVID vaccinations for your employees? You have to make certain exceptions. Can you ask your employees to sign liability waivers? Are there other things you can do to mitigate your risk? These are kind of another big bucket of issues. So I'm I'm available and ready to answer questions on any or all of these topics, and frankly, any other legal issues that you'd like to ask me about. I have been doing this for 25 years, and I have a very, very kind of broad knowledge base of virtually every legal issue that nonprofits deal with. So if there's anything else that is on your mind and you want to hear about today, it's certainly not just limited to COVID-related issues. Does anyone have a preference of kind of where you want me to start? Any issues that are more pressing to you than others? I know we did get one question that Dave forwarded to me in advance from one of you, which I'm happy to start with, relating to contract clauses. But if anyone has a preference, please let me know.
I'll just start with that, which is related to meetings, and then we can just open it up from there.
Okay.
Thanks.
So one of you guys, or I should say, one of you, Deborah, yes. We are about to sign a contract for a hotel conference for fall of next year, fall of 2022. Any considerations for cancellation clauses that we should try to include? We've already paid cancellation fees twice, last year and this year, although we have negotiated a partial refund with next year's contract. But if we have to cancel again, I hope not, it could happen. So yes, this is a very important topic. In fact, my colleague Nisha and I have been doing several webinars on meeting contract provisions specifically, focused on kind of future contracts and what sort of things should you include. Some of these things are related to COVID and cancellation. Some of these things are much broader and kind of have always been kind of tricks of the trade. But certainly the pandemic has brought issues of meeting and contract cancellations to the forefront in a way that I've never seen before in all the years that I've been doing this. And so it definitely informs what sort of provisions should you try to negotiate in your future contracts. And remember, every contract is a negotiation. And just like in every negotiation, I negotiate for a living. Sometimes you have more leverage, sometimes you have less. Sometimes, your leverage is what you make of it. Sometimes you don't get something if you don't ask. If you ask for more, you're likely going to get more. Not everything, but you're going to get more. If you're willing to pay more, have a bigger meeting, enter into multi-year contracts, with a venue, you're certainly going to be able to have more leverage. The size of your meeting matters, the time of year, what their general occupancy is at that time of year. All of those things factor into your leverage. And so I'm not going to get into specific analysis of leverage because that's so fact specific, but I will say here's some things that we try to work with our clients to try to get them to include, or if we're usually actually not doing the negotiating in their behalf. In most situations, our clients are the ones doing the direct negotiations, and we're kind of behind the scenes advising them, reviewing the draft contracts, marking them up. And then it generally works best if you guys are the ones doing the negotiation directly with the hotel or convention center. But a few things that we've been trying to include that we've kind of learned from COVID. One is to include, and this is not something we usually did before, something that we've been trying to include, which is something tied into the cancellation provision that says if you have to cancel for any reason. Now, of course, if it's a force majeure cancellation and it qualifies as a force majeure termination, then you should be able to cancel without penalty. Now, granted, as we saw in the hundreds of conference cancellations that we worked on last year, you may believe you have a strong case for force majeure termination. The hotel or convention center might push back and disagree, and sometimes that itself becomes a negotiation, and sometimes the lawyers get involved. So certainly the force majeure clause is really important, and you want to have it be as broad as you possibly can, because that's a provision that says if some unforeseen event happens or some list of XYZ events happen, and it makes it illegal or impossible, or what we try to include commercially impracticable to hold the meeting, then we can cancel. Either side can cancel without penalty. On the force majeure clause, that adding language about the unforeseen event making it commercially impracticable to hold the meeting is very, very important. If it just says illegal or impossible, which is what probably 85% of most nonprofit force majeure clauses in their meeting contracts say, that basically means that unless state or city or county, has some restriction on the ability of large groups to meet like yours, like we saw last year, then you're not going to be able to get out without penalty under the force majeure clause. But if you can add commercially impracticable, which is kind of a well-established term that has a legal meaning to it, it gives you a much broader avenue to argue that other things, for instance, employer-imposed travel bans or other things like that, make it commercially impracticable for you to hold the meeting. So that's important to add in the force majeure clause, and you're going to get pushback on it. A second thing to add is that in the cancellation provision, it says if you have to cancel for any reason, particularly something that's not covered by force majeure, then as long as you rebook a similarly sized meeting within the next, what we usually try to say 24 months, then any cancellation fees that you have to pay will be treated as an advance deposit for that future meeting. So giving you kind of an automatic right to rebook similar size meeting within the next 2 years. And, whether you say all the cancellation fees or half of them or whatever, as long as you can make it be a deposit toward your future meeting, then you're not throwing money away. Just keep in mind that if the sleeping room's involved, cancellation fees are designed to approximate what the hotel would have earned if you held the meeting. That's going to include both sleeping room revenue, largely which is paid by your attendees, and then food and beverage revenue, largely which is paid by you, or all of which is paid by you, the organization. And so you don't want to be paying more in a deposit than you'll actually be paying when you hold the meeting for food and beverage, because the sleeping room part, that's going to be paid by your attendees. So keep that in mind. I had a client this morning asking what is the right amount in that situation, because they're in a negotiation, to try to figure out the deposit should be. And I said, just make sure it's not any bigger than what your food and beverage minimums are. So that's one idea. Second thing is, and this is happening a lot right now. A lot of organizations are having meetings, by the way. In-person meetings are happening now. They're going to continue to happen. There's also a lot that are going to be canceled or postponed. But everyone that is holding in-person meetings, say for the rest of this year, is recognizing that you are going to have significantly reduced attendance. You're not going to get the number of people that you would typically have. In fact, we're hearing for some of the larger meetings that they're lucky to get half of the normal budgeted attendance. And so there's another provision in most meeting contracts called attrition. And attrition is the penalties that you pay if you don't meet your guaranteed minimums for sleeping room revenue and food and beverage revenue. If you can't get relief from the hotel on the attrition penalties, you are going to get slammed if you hold a meeting and you have 50% attendance. The attrition penalties could even be more than the cancellation penalties, but certainly very significant. And what we have seen, though, is that hotels are very eager to have you back in person. And so we are seeing more often than not, most hotels are being very flexible and accommodating, sometimes in eliminating the attrition penalties altogether, but certainly in reducing your minimums for food and beverage and sleeping rooms significantly. That's really important. And you want to also try to build that in to your future contracts to the greatest extent possible, to be able to reduce those minimums as close to the meeting date as you can. And also the penalties are generally based on, so for instance, for sleeping rooms, it'll say if you don't meet 80% of your minimums for sleeping room or for food and beverage, then you have to pay these attrition penalties. You want to try to get that percentage lowered as well. And then finally, we've been doing this for years, always try to include a mitigation clause that says if you are forced to cancel, then the hotel has an obligation to resell those sleeping rooms and or meeting space, but particularly the sleeping rooms. And then whatever they resell, you get a credit for that. So the hotel doesn't get to double dip, and profit off of your cancellation fees as well as resell the room. So resell, and then you get credit back for those. So I could go on all day about the meeting contracts, but those are some suggestions of what to include. I see we have a lot of questions.
Well, Adriana asked other things to consider now for 2022 in-person meetings. You mentioned some things related to contracts, perhaps to think about for meetings next year. Any other major considerations?
Well, I mean, right now, for meetings next year, it's all about the contracts and trying to give yourself the flexibility, because we just don't know how things are going to go with the pandemic. So I just gave you some suggestions. Another, well, let me just see some of these questions so I can answer what you guys want to hear about. Always interested in what employees can or should be doing on voluntary business travel. Is it prudent, especially now, to leave it up to their best judgment? So I had a question yesterday from a client. He said, we're a small staff organization. We're planning on holding an in-person meeting, and we need all of our staff there, in order to staff the meeting, because we just don't have enough people otherwise. And one of the staff is very reluctant to travel. I can't remember if the staff person is immunized or not, but the person is reluctant to travel. And they said, what should we do? I said, look, technically speaking, if that is part of their job duties, and they don't have any qualifying medical condition under the Americans with Disabilities Act that would require you to make a reasonable accommodation for them, then if they just are scared to travel or scared to go to a large meeting, technically that could be deemed to be insubordination, and you could discipline or terminate someone for that. The practical reality is right now at this particular point in time, I would not advise that, more from a just compassion perspective, and that a lot of people are still very concerned about traveling and going to large meetings and whatnot. And I'd say try to find alternatives, try to hire local contractors, get local volunteers, other things like that to try to substitute for staff. But at some point down the road, especially for smaller staff organizations, which most of you guys probably are, there's only so much flexibility you can give people. And you are allowed, to impose work rules and require people to follow those, whether those work rules are, you have to be in the office 3 days a week or 5 days a week, or, you have to travel for work or things like that. Particularly as the situation becomes safer, that's something you're certainly allowed to impose. A related question I get all the time is, can we require our staff to be fully vaccinated from COVID? And the short answer is yes, you can. Even under the current emergency use authorization that the FDA has given the 3 approved COVID vaccines in the US, you can, but you have to make 2 exceptions. One exception derives from the Americans with Disabilities Act, and many states have their own state equivalent that apply to smaller staff or employers. And that is that if you have a qualifying medical condition that would make it dangerous or risky for a staff person to get one of the COVID vaccines, then you have to make a reasonable accommodation for that person, so long as the accommodation does not pose an undue burden on your organization. That reasonable accommodation could be allowing them to continue to work remotely. It could be requiring them to come into the office, but to show weekly proof of a negative PCR COVID test within 72 hours. And wear a mask and socially distance at all times, or perhaps some other reasonable accommodation. But if someone fits into that category, you do have to make that reasonable accommodation. I will say that while there's still a lot that's unknown about the vaccines right now, what I've read and heard is that there are actually very few medical conditions that are proven to be I forget the word, but basically dangerous to get the vaccine. We're seeing a lot of employees saying they don't want to get vaccinated and throwing, every type of medical condition out there that you can imagine. But you're allowed to require a doctor's note, to substantiate their claim. And you're allowed to ask questions and push back on that if you have reason to believe that it's not a valid claim. And you don't, just because I have a call tomorrow morning with a client that has 2 employees, one who made an ADA exception from the vaccination requirement that the employer is imposing, and another that's making a religious-based request for an accommodation that I'll talk about in a second. And we're going to go through and evaluate and see how credible it is. I had another client that had an employee who made both objections, both the religious and the medical condition. On the medical condition, the medical condition that she raised there's absolutely no evidence whatsoever to suggest that the vaccines would be dangerous to take in that with that medical condition. And on the religious objection, Title VII of the Civil Rights Act says that if you have a sincerely held religious belief that would prevent you from being vaccinated, that, again, the employer has to make a reasonable accommodation for that individual, as long as it doesn't pose an undue burden and so long as the employee can still perform the essential functions of the job. But here, the employer actually had good reason to believe that it was not a sincerely held religious belief. One of my colleagues did a little Google searching and found a conservative website that had a form letter that employees could send to their employer, claiming the religious exemption from being vaccinated. And she literally copied and pasted the exact form letter. And it really didn't seem to pass muster. And again, that's a much tougher one to gauge, whether it's a sincerely held religious belief, because, for instance, a sincerely held political belief does not qualify. But again, those are the two exceptions where you have to make a reasonable accommodation. Beyond that, you can mandate vaccinations. So you have kind of several options. You could say everyone has to be fully vaccinated, period. And, now get, the appropriate booster shots at the appropriate time. Alternatively, you could say you either have to be vaccinated or show, say, weekly proof of a negative COVID test and wear a mask and socially distance whenever you're in the office or traveling for work, et cetera. So if you do that, that kind of is the reasonable accommodation. Then you don't even have to deal with those two exceptions. Or you could say you either have to be vaccinated, or if not, then you have to wear a mask and socially distance, when you're in the office or traveling for work. You kind of have those options. Every employer is different. The culture, the geography, the politics, all of this factors into it. But from a purely legal perspective, kind of those are your options. And since I'm on the topic of vaccinations, let me just pivot for a second to meetings and conferences, because what we are seeing is that some larger meetings and conferences, I just heard yesterday that the big CES, Consumer Electronics Show in Vegas each January, a huge show, is going to require vaccinations and proof of vaccination in order to attend the show in January. And we're seeing more and more of that being contemplated or announced. Can you require attendees at your conferences to be fully vaccinated? Yes, you can. You absolutely can. You can also require proof of vaccination, whether it's people showing you their CDC vaccination card, or more preferably, what I recommend is using one of the companies out there, like Clear is one of them, the airline security company that has an app and a process for kind of clearing people who are vaccinated in advance of conferences. And they have an app you download on your phone. Your attendees can do it in advance. They upload a copy of their vaccination card, photo ID, and a picture of themselves to the Clear app. And then the Clear company kind of goes through and screens them and gives them kind of a green check mark that shows up on their phone that they can show you at the conference. We generally recommend doing that because it shifts the burden and the liability risk over to that company, and just makes it a lot easier for you and your staff for how to deal with those issues. But you can do that. The one exception you have to make is Title III of the Americans with Disabilities Act, which is different from the title that deals with employment. But Title III says that if you are holding an event in a place of public accommodation, which would include hotels and convention centers, then you have to make reasonable accommodations for people with qualifying disabilities in order for them to get the full benefit of the place of public accommodation. And what that likely means here is that if someone has, again, that qualifying medical condition that prevents them from being vaccinated, then you have to make a reasonable accommodation for them. Again, the accommodation could be showing daily proof of a negative COVID test. It could be wearing a mask and socially distance. It could be providing, the educational content in digital form to them, or having a virtual, hybrid meeting or something along those lines. But with that one exception, yes, you are allowed to mandate that. One little wrinkle that you might have heard about is that there are 5 states, Texas, Florida, Alabama, Iowa, and North Dakota, that ban businesses in the state from requiring proof of vaccination as a precondition of entering that business. There are also a number of others, I think 13 additional states that also ban government agencies from doing that in the state. But only 5, as of right now, this changes all the time, only 5 ban businesses. But the way that those statutes are written and the way they seem to be interpreted by the hotel lawyers in Texas and Florida in particular, which are both big states for nonprofit meetings, is that while the hotel cannot require proof of vaccination as a condition of, say, entering the hotel. You, as a licensee, you know, as a renter of space in that hotel, you can impose a mandatory vaccination requirement, including proof of vaccination, if you want to. And that's what, so far, anecdotally, that's what we're hearing from hotel staff people in Texas and Florida, is that if you want to do that, you're allowed to do it, and those laws would not apply to you guys per se. And I will also say that those laws, at least as of now, do not apply in the employment context. So there's no states that I'm aware of that require that ban, you know, asking employees for proof of vaccination. And then one last point I want to make, and this is a long answer too, but it's a lot of kind of multifacets to this issue. Back to the employment front, if you ask for proof of vaccination, the EEOC has said you're allowed to do that. It's not a HIPAA violation, because HIPAA doesn't even apply in this context, because you're not a healthcare provider. I mean, unless you are a healthcare provider, but generally for nonprofits, HIPAA is not going to apply outside of your health plans. But there is a provision of the Americans with Disabilities Act, if the ADA applies, that says that you have to keep medical information about your employees strictly confidential. So what the EEOC has said in a whole FAQ document is that if you're going to require proof of vaccination, do not store that information in the employee's personnel file. Keep it separate. Keep it in a very highly secured, you know, say spreadsheet or document with limited access, you know, to only say maybe, you know, the CEO, maybe the HR director, et cetera. But you are allowed to ask employees for proof of vaccination without violating their privacy rights. Okay, that was a lot, but let's see if we can get some other questions. I'm probably
Liability waivers, what about?
Okay.
Can you talk about
so on the employment front, because any claims that an employee would bring that they contracted COVID at your office or traveling for your work, and you were somehow negligent in allowing them to contract the virus, those would generally have to be brought under workers' compensation statutes. And most states' workers' compensation statutes say that it's illegal for employees to waive their rights under workers' comp statutes. And so any liability waivers that you would have your employees sign would be null and void. So no liability waivers on the employment front, but on the conference and meeting front, no brainer. Absolutely, you should absolutely, in my opinion, have all attendees click and accept or sign that they agree to a liability waiver that says, I recognize COVID's a dangerous virus and it's impossible to completely protect against it. And basically, I recognize that there's a risk I could contract COVID at your event. And if I do, I agree not to hold you liable. While liability waivers do sometimes get struck down by courts for different reasons, the two biggest reasons are if your organization was grossly negligent or engaged in intentional misconduct, a liability waiver is not going to hold up in court if it was challenged. And the other reason is if someone says, well, I really didn't realize I was agreeing to this liability waiver. If it was just buried in some fine print and, you know, you say somewhere that by registering for this conference, I agree to all of these terms and conditions, and it's just buried in there, that could be another reason why it could be struck down by a court if it was challenged. That's why we recommend that you have some sort of, like if it's an online registration process, a kind of a pop-up box where people have to click and accept that they agree to the liability waiver. And then I would also, by the way, in your liability waiver, put in two other things. One, saying that the attendee agrees to abide by all of your rules and terms and conditions of attendance at the conference. And second, that all of this is subject to change at any time. Because as we're seeing, you know, we had, like in DC where I'm located, we had a period of time, I don't know, a month, 6 weeks, where if you were vaccinated, you didn't have to wear a mask indoors. Now, irrespective of vaccination status, everyone over 2 years old has to wear a mask indoors in DC. These things change or are going to continue to change on a regular basis.
Thanks, Jeff. Claudia had asked, I think you answered this, but she understood you advised before that they can establish any safety requirements that they believe necessary, negative COVID test, vaccination, mask, etc. Please confirm that this is correct in the involving.
Are we talking about, Claudia, is this in the employment context or the meeting?
That sounds like workplace, but.
Sorry, I'm sorry, it was meetings. And I think you kind of answered it. You went all the way to vaccination. So I presume that all those lesser things are also included.
Yeah, and you could have a belt and suspenders approach. I mean, if you wanted to. Now, granted, that would be, people would know that that's overboard and not what most organizations are doing. But you could say vaccination requirement and negative COVID test and mask wearing and social distancing at all times. Again, that would be a lot, but if you had an audience that, was just super, super cautious and concerned, and that's what it took, you could do that. What we're more often seeing is mandatory, either vaccination, full vaccination, or negative COVID test and mask wearing. And sometimes mask wearing for all. I mean, right now that's, and that, by the way, from a liability perspective, you of course have to follow whatever local restrictions are in place from the state, city, county. If there's an indoor mask mandate, obviously you have to follow it. But even if there's not, say you're in Florida or Texas and there is no indoor mask mandate, as we know, quite the opposite actually. The governors say the cities and counties and schools and everything else cannot impose mask mandates, which are being challenged, by the way, in court. But you also, from a liability perspective, in terms of not being negligent in how you hold the meeting, you always want to follow the prevailing federal guidance, which in this case comes from the CDC. And the CDC says, they recommend right now that even for the fully vaccinated, you should wear masks indoors. And so right now, until the CDC changes that guidance, that's what I would recommend that you do. Even if you're in, like, and I've been doing some traveling into some states for speaking and whatnot. And in some states, there is just a culture of, you kind of get shamed if you wear a mask. And I mean, you guys know where those states are. And so that becomes difficult if you're holding a meeting there. But, if you want to mitigate your risk and you really want to follow the CDC guidance, which says for now, even fully vaccinated, wear masks indoors.
So Joanne's asking, I think this is about employees. Is there a liability if people want to voluntarily have face-to-face meetings and travel when we're still in virtual mode for events in office?
So if your employees, you're not mandating it, but your employees want to, get together on their own in person, or travel for some, maybe for some conference that's taking place or some out-of-town meetings or something like that. One option would be to say, no, it's against our policy. We don't feel it's safe to do that, and you're not allowed to do that. And you certainly could. That's one option. If you wanted to allow them to do that, like I said, a liability waiver is not going to fly because it would be challenged if you try to enforce it. But what you could do is impose, create a policy that you issue to your employees that says, if you voluntarily choose to meet with other colleagues or travel for work or engage in other face-to-face meetings, then you agree to abide by the following terms and conditions. You have to be fully vaccinated. You have to wear a mask and socially distance at all times. If you have any COVID-like symptoms, you shouldn't go. You agree not to engage in any risky activities while you're doing this. And by the way, you're doing this completely voluntarily on your own. If you have all of those things and it's clearly communicated to the employees, then it's going to be much more difficult for someone to later bring a claim against you that you were negligent in how you operated the business, how you operated the organization. So that's what I would recommend.
Thanks.
Thanks, Jeff. Have you seen anyone put vaccination requirements into job postings?
Not yet. I haven't seen it, but I'm sure it has happened. Actually, I take it back. DC government, can't remember if it's for all workers or just healthcare workers, but I think it's all workers. For current employees in the DC government, you either have to show proof of full vaccination or show weekly negative PCR COVID tests. But for all new hires, it's a mandatory vaccination requirement. So yes, I have seen that. Claudia asked about the ADA and the applicability, and it's a great question. ADA applies to employers of 25 or more full-time employees. That's probably not going to cover most of you, but many states like DC have their own state equivalent of the ADA that in DC applies to all employers. And it's basically the same law. Now some states don't, but frankly, even if the ADA, or if you're in a state that doesn't have its version of the ADA, I still think it's becoming a best practice, and it's what people are expecting to make, well, certainly to keep the confidential medical information confidential about employees. And that's just a no-brainer, because that could trigger, other claims that an employee could make if you weren't careful with that information. But in terms of making, the reasonable accommodation, there are, while the ADA itself might not apply, there are other claims potentially that an employee could make. I could come up with some creative claims to make, if you did not make a reasonable accommodation for someone that had a qualifying disability that prevented them from being vaccinated. So I would basically recommend following those two exceptions, even if the ADA doesn't technically apply to your organization.
Thanks, Jeff. Any guidance out there for nonprofits who work with volunteers for in-person gatherings?
Yeah, I had this question yesterday from someone on a webinar I was doing. If you're going to require all conference attendees or any kind of in-person gathering, if you're going to require it of your staff, if you're going to require it of your attendees, then you should require it of anyone else who's going to be interacting with them, including volunteers. So whatever policies you're going to have, vaccinations, negative COVID tests, whatever, mask wearing, it should absolutely apply to your volunteers as well. And we're also seeing some organizations are asking the hotels to be sure that all hotel staff that are going to be in any way interacting, from housekeeping staff to front desk staff to catering staff, that they all be fully vaccinated. And what we're seeing so far, what I've heard anecdotally, is that most of the hotels are being very cooperative with that. And of course, that would also apply to any vendors or contractors that you're bringing in to assist with things, AV folks, things like that, if you're bringing in outside folks.
Great. What about requiring your attendees to present a negative COVID test? I guess
I think I've already covered
in addition, maybe I don't know, maybe in addition to vaccination, since people who are vaccinated, some of them are getting.
Yeah, I mean, that's what I was saying to Claudia. It's a belt and suspenders approach, and certainly it would not be, a crazy idea to do that. It would just not be the norm. I'm not seeing that yet. I've never seen that yet, but it's not to say that it's wrong, because as we know, no vaccine is bulletproof, and showing a negative COVID test. I mean, if you were going to do that, I would think that it would be in your best interest to facilitate the COVID testing. I mean, we know that the rapid tests are not as accurate as the PCR tests, but it's better than nothing. And so maybe if you had on-site rapid testing or something like that, and you paid for it, that would probably be a lot more palatable to folks. And and it's not just about your organization being too overbearing or something. It's also about making your attendees and your staff feel comfortable and safe. And we're hearing this all the time from employees, from conference attendees, members of organizations or associations, saying, look, we want you to impose these requirements because we want to feel safe in the workplace, at your meetings and conferences, gatherings, things like that.
Right. Claudia mentioned the no mask culture is a problem when you're running events for membership that is demanding in-person meetings in an area with a no mask culture. Do you or anyone else have this problem, and or any suggestions about how to deal with it?
Yeah, I wish I had a solution. Granted, this was back at that interim period when the CDC had said, if you're vaccinated, you don't have to wear masks indoors. But I was at a meeting in Chattanooga, Tennessee, a conference there, and yeah, there was never a mask in sight anywhere, from hotel staff to anyone else. And the organization I was speaking for, they did not have a mask mandate, again, because of the time period. But they had the same organization held a conference last year, completely different, where masks were everywhere and all the other stuff that went along with it. If they were to have imposed a mask mandate at that conference, when even the hotel staff were not wearing masks, that would have gone over like a lead balloon. That would not be a good solution. And look, I don't know what the answer is, but one thing is perhaps if you are scheduled to hold a meeting in a state or a city that has a very much anti-mask culture and you feel like you need to impose a mask mandate, is to try to move the meeting. Again, now we're going to get back to these issues of the hotel contract cancellation clause and everything else. But it might be a better option to move it to a place where there is no anti-mask culture, like hold your meeting in DC or something like that. We got another Marriott-owned property in another state. Whereas if it's just managed by Marriott, then it means it's locally owned, and they're going to have no interest in allowing you to do that. By the way, speaking of that, thinking back to another conversation I had this morning with a client, giving him some negotiating tips for trying to get out of that meeting contract in San Antonio, Texas. Where the force majeure and the cancellation clause, it's just terrible and really gives them no ability to do a force majeure termination. And as I said earlier, hotels in Texas and Florida in particular just seem to be digging their heels in with this stuff because they know from a purely legal perspective and just culturally, it's they're just digging in and not granting a lot of concessions. Even in those, and they've already pretty much said, we're not going to just let you rebook and, do the meeting next year or the year after and waive cancellation penalties. But there are some negotiating tips that we've seen some organizations have good success with. For instance, not just let us move the meeting to next year and we go our happy way, but offering that plus some other things. So for instance, that plus maybe another smaller meeting, a board meeting or something else a year or two down the road. Adding that plus, instead of paying cancellation fees, paying more in an advance deposit so that the hotel because they want cash and they want it now, but paying an advance deposit either all at once or over a period of time that will be credited toward your future meeting. That's something that we've seen a lot of organizations have some great success, coupling that with, the rebook of the meeting, perhaps paying some cancellation penalties. I hate to see organizations pay cancellation penalties because that's just lost money. Whereas if it's a deposit, you're basically just prepaying money that you would be, paying anyway. We don't like organizations have to pay deposits because what we see is if you have to cancel, you can forget about getting that money back. I've yet to see an organization that canceled a meeting get their deposit money back. It affects the hotel's negotiating posture if they have a lot of deposit money versus if they don't. But still, if that's what it takes to grease the wheels and get out of the cancellation penalties, I'd rather have you pay a bigger advance deposit than pay cancellation fees. And another thing that we've seen help grease the wheels is if you're willing to increase your food and beverage spend, going to have a nicer event, for your attendees and whatnot, maybe an additional reception or up the quality of the food and drink and other things like that. Again, that's very profitable for the hotels, so they're often interested in that. Someone asked, has anyone sued their employer over any of this yet? There's a lot of litigation on the employment front over COVID. Particularly there's a lot of class action litigation that's ongoing in connection, like against a lot of the big meat processing companies, factories, where there are big COVID outbreaks and whatnot, and basically claims that the employer was negligent in how it operated. And now we're starting to see some litigation, over vaccination mandates and mask mandates and things like that. I was reading an article earlier this morning that was in the Washington Post about the fact that if people who have qualifying disabilities bring a lawsuit against the anti-mask mandates that Florida and Texas have imposed, they likely will be successful in saying that it's about like the anti-mask mandate in schools in Texas and Florida. That, if someone brings a suit or class action suit under the Americans with Disabilities Act saying, look, my child needs to wear a mask because they're immunocompromised and it's dangerous for them not to, it's going to be difficult for the state, the school district to prevail, that they can't make reasonable accommodation. They're still going to, ban masks in schools. Another question, Jeff, we've had luck that we have done
Another.
advanced deposit of 500 or 1,000 and broke it up into two smaller meetings. Yeah, that's kind of that basically what I was just saying. Offering up, not just a read book, but maybe an additional meeting, and then offering more advanced deposits. That's sometimes how you can get the hotel to move off the dime.
Great. We still got a few minutes left. Welcome other questions either in the chat, or if anyone just wants to unmute and share your question, give you that opportunity. Oh, there's one more from Tanya. Jeff, hiring.
Yeah.
All right.
Happy to give context. If some of us are hiring, we have been hiring, and generally it's my understanding if anyone needs either physical, mental health, whatever accommodation, we don't discriminate during the hiring process, of course, but I am aware that I should be informed if accommodations are needed that from pre-existing issues with the employee. We're so small, we're abiding by everything, but having had a couple staff who have needed to take leave for mental health reasons, like I'm starting to get concerned about what I didn't know about hiring during the pandemic. And we are trying to just be gracious employers, but also I'm starting to get concerned that folks can turn around and say, oh, well, you made a decision and that sent me into a tailspin during the pandemic. And it's just an interesting quandary that we seem to be almost on the edge of it at my org.
Well, I mean, I'm not sure that the pandemic really changes anything. I mean, first off, whether the ADA applies, if you only have 15 employees, then it doesn't, but whatever state you're in might have a state equivalent that might apply. And certainly you have the Federal Family Medical Leave Act. But, in general, a mental health issue certainly can be a qualifying disability under the ADA. And you have to make reasonable accommodations for someone that might. We had one recently, a request for an accommodation under the ADA for mental health issues, and the employee was asking for basically a temporary ability to work part-time for, say, the next 6 months so that she could deal with these issues through therapy and otherwise in treatment. And she had a doctor's note kind of supporting that. The employer had a tough call because they've already been making an accommodation for her for some time. And in the department of the organization that she works for, it's really put a strain on the rest of the staff because, everyone else has been picking up her job duties. So where we ended up landing, look, and it's always supposed to be, the ADA says it's supposed to be an interactive discussion with the employee. And a reasonable accommodation, by the way, is not just what the employee wants. It's any reasonable accommodation that does not pose an undue burden on you and that still allows the employee to perform the essential functions of the job. And you can decide, what reasonable accommodation you want to make. It doesn't have to be what they want. You should talk it through with them. So you try to strike the right balance. But for instance, if someone's reasonable accommodation they request is they want to take the next 3 months off and still get paid, and they've already exhausted their leave bank, no, you don't have to give them paid time off to do that. If it doesn't pose an undue burden, could you give them, unpaid leave? You certainly could if you wanted to. But, you got to strike the right balance. And I know that the pandemic has exacerbated mental health issues for a number of folks in the country. But it really doesn't change the legal analysis in how you deal with these things. Someone asked, when we're hiring, can we ask candidates if they're vaccinated? So here's what I would say to that. Sure. Basically, yes, you can, but you always want to be consistent and objective in how you deal with these issues so that you don't ever develop, a claim for disparate treatment that someone's alleging you're treating certain categories of employees differently than others. So I would say if you're going to have a mandatory vaccination requirement for all employees, or, either vaccine, or like DC government is doing, either for current employees, either you're fully vaccinated or you show weekly proof of a negative COVID test. For all new employees, you have to be vaccinated. If that's your policy, put it in place, make it clear, and then enforce it consistently. And then, yes, you could ask that. Or you can basically say, look, here's our policy. So basically don't bother applying unless you're going to be willing to show us proof of vaccination if you get hired. And one other thing the EEOC has said is that don't ask any questions. It's okay to ask whether you're vaccinated and to ask for proof, but don't ask questions beyond that, like why aren't you vaccinated or anything like that, because that can cross the line in terms of questions you're not supposed to ask under the protections of the ADA.
Paul has a hand raised, I think, for a question.
Sorry, say that again.
Paul's got a question. He raised his hand. So.
Oh yeah,
Thanks,
I see.
David, and thanks, Jeff, for everything. This is extremely helpful as this evolves. We've had a few conversations with other nonprofits where we're based who have wondered what our health premiums going to look like for vaccinated versus non-vaccinated employees, now that the vaccination is fully available to folks, how that might handle, and especially if there's going to have to be two different premium rates if someone's vaccinated versus not vaccinated. That's come up with a couple nonprofits because they're just finally getting to a health insurance level. So it was just brought up to me. We're not looking at it in our shop, but someone asked the question to me and I thought I would inquire.
Well, I mean, as I said earlier, it's not unlawful to require all of your employees to be vaccinated. The reason the EEOC says is because COVID is such a dangerous virus and it poses a risk to others at the workplace, and the vaccines are safe and effective, according to the CDC and the FDA. So therefore, it is okay to mandate vaccinations. If that also has the benefit of helping to keep your health insurance premiums down, and that's an interesting question. I hadn't even thought about that or heard of that yet. Whether health insurers are going to start asking, what's your risk profile of your employee pool by asking who's vaccinated and who's not, and charging, if you have more, if it's group health insurance, it's a shared risk, right? And so the more unvaccinated folks you have in that pool, the greater the premiums are going to be for everyone. And so, I mean, that's fair game if you want to do that. I mean, and if you don't want to mandate vaccinations, and if that's where health insurance premiums and that's how the market ends up evolving, then everyone's probably going to end up paying more, both you as the employer and whatever the employee's share is, if there is any.
Thank you.
Thanks, Paul. So probably have time for maybe one more question or two. So if you had last chance, if there's something you wanted to ask of Jeff, now is the time to do it.
All right. I think we've got, we answered a lot of questions. Hopefully you guys found this helpful. I know I've done this before, and the questions and the answers seem to be very different today than they were the last time we did this and the time before. But I always love speaking to you guys, and glad to do this again. And I'm sure we'll have a very different discussion next time around as well.
Thank you. Please join me in thanking Jeff for his time today and sharing his expertise. And Jeff, we'll see you again soon, and look forward to seeing all of you again soon. Take care, stay healthy and safe.
Sounds great. See you guys.
Bye all.